The D.C. Circuit ruled against the FCC today in its case against Comcast, where Comcast was challenging its authority to protect consumers of broadband internet access. The FCC had relied on a theory called ancillary authority, where even though it acknowledged that it didn't have direct authority to regulate broadband internet access, it argued that unless it could regulate broadband internet access, other provisions of the law would be undermined. It mostly relied on Section 230 of the Communications Act, which directed the FCC to promote the deployment of the internet.
The problem was, when the court examined these bases for FCC authority, it described them as policy statements, not express delegations of power. So the court said, yes, ancillary authority does exist, but it needs to be ancillary to an express delegation of power. It can't just be ancillary to a policy statement. And all the things you've been pointing to FCC, those are all policy statements, so you can't justify ancillary authority over broadband internet access.
Now, ancillary authority is a theory that the Supreme Court came up with, so the D.C. Circuit, even if it wanted to, couldn't get rid of it. So instead of saying that ancillary authority is just not a valid way to go about regulating broadband internet access, it said, okay, first of all, your specific use of ancillary authority here, the way you've argued for it, doesn't work. And also, every single time you need to use ancillary authority, you need to separately justify it. That is, there's no such thing as ancillary authority over broadband internet access. There's only ancillary authority to promote open internet rules, to promote transparency in billing, to promote universal service. So the FCC, if it wants to continue relying on ancillary authority, theoretically can do it. It's going to need to argue for it each time, and it's going to probably need to defend it in court.
Now, this entire thing is completely self-inflicted by the FCC. When they made a decision a couple years ago to place cable broadband internet access into Title I and to move DSL broadband access from Title II into Title I, they basically turned their back on an explicit delegation of power in Title II. We at Public Knowledge think the best way to deal with this and to be able to regulate broadband internet access and to protect consumers online would be for the FCC to move broadband internet access back into Title II, where they'd have an express delegation of authority, and there'd be no question as to whether or not we should be using ancillary authority or anything else.
The FCC already has all of the legal authority it needs. It just needs to use it.